Welcome to the Binary Agora. In this series, we dive deep into the world of legal tech, breaking down its challenges, its innovations, and also real world impact with insights from top researchers, officials, and also practitioners. And today we have with us Konstantinos Stylianou, professor of competition law and regulation at the University of Glasgow, and he's also a non governmental advisor to the Hellenic Competition Authority. And his work focuses especially on digital markets, also blockchain, and high tech industries in general. And I believe that he's a perfect choice to discuss this complex and also intricate ruling that we will be discussing today, the Court of Justice's Android Auto ruling. So, welcome to the Agora, Konstantinos.
Thank you for having me. It's a pleasure to be here, and thank you for the opportunity to share a few thoughts on the Android Auto case. It's an important case. I think people are gradually realizing the widespread effect that the case might have, because it introduced an important distinction that in a way was long overdue. But I think that the way that it was done in this particular judgment, it wasn't done with a kind of precision that we would expect on an issue of such importance. So I would be happy to go into some details as to what the judgment says, how it could have been improved, and what the issues around it are. So, if I can just briefly mention the facts of the case so that everybody's on the same page. So Android Auto is essentially a mode of the Android operating system which activates when a driver connects their phone to the car's multimedia system. It allows drivers to not look at their phone, but rather look at the screen of the car for use of the apps that they have on the phone. Now, importantly, not all apps are available on Android Auto. Not all apps are accessible in that specialized driving mode, but rather only those that Google has ported into Android Auto by creating a so-called template, which is basically a way to enable the phone app to show on the screen of the car's multimedia system. Now, the reason why this functionality is important is because it makes it a lot easier to use one's phone while driving. The screen is bigger, it's at a place that is more easily viewable and accessible to the driver, it's safer, and the fact that there are fewer apps on the platform means fewer distractions as well. One of the important parameters, so to speak, of the case was that the app in question, Juice app, was not available on Android Auto, but was still available for use on the driver's phones, including while driving. So what happened is that the developer of the Juice app application, they wanted to bring that app on Android Auto, and Google refused, saying that we don't have the necessary template to allow the app to go on Android Auto. And NL thought that this was anti-competitive because it put its own app in a competitive disadvantage, since drivers could not access the app on the Android Auto mode, and therefore it would make it much more difficult for the drivers to access the app.
Other types of apps were already available on Android Auto OS, such as, for instance, music apps.
That's correct. A number of applications were available on Android Auto. Google Maps, importantly, was available on Android Auto. It didn't fully 100% compete with Juice app, but both could direct users to charging stations for EV cars. The allegations was that Google is showing some sort of preferential treatment towards its own Google Maps application at the expense of Juice app. And now I'm using the word preferential treatment not in the self preference offense definition according to Google search, but rather just to say that NL felt that its own app, which partly competed with Google Maps, was in a competitive disadvantage because people could access Google Maps on the Android Auto platform, but they couldn't access the Juice app. So it complained to the Italian competition authority. The Italian competition authority sided with NL, and it said that access seems to be indispensable. It asked the Court of Justice on that particular question on whether access to Android Auto is indispensable for Juice app to compete, and it asked it, what do we mean by indispensable in this particular case if the app is still available on users' mobile phones? The Court of Justice in a way hijacked the question of the Italian competition authority, and instead of discussing the question of whether access to Android Auto was indispensable, it instead recast the question of whether do we still need the condition of indispensability on platforms like Android Auto, and then it went ahead to answer that question with the guidance that the Italian competition authority received. It deemed that it was indispensable, and it said that Google must make Juice Pass available on Android Auto.
On this point that you were just addressing on the Court of Justice's reshuffling of the cards that the Italian Competition Authority had given it, wouldn't you say that there's a sense that the Court of Justice wants to really set its own path in terms of how it interprets digital markets because it has not had so many opportunities to do that in the past?
So I think that's absolutely right. It's very hard to like second guess what judges had in mind when they recast the questions of the Italian competition authority. But I think there was this sense that for 20 years, even, we've been talking about platforms and their position in digital markets and the role that competition law has to play in safeguarding competition on platforms. And I think that this was a golden opportunity for the Court of Justice to, for the first time, essentially weigh in terms of how do we understand the refusal to deal in this space. We have had a long case law on refusal to deal cases. Many of them are in the old economy. We've had Microsoft, which was 20 years ago. But Microsoft, for the most part, is in line with the previous case law of refusal to deal cases. It dilutes some conditions to some extent, but in its core, it does not substantially change the concept of what it means to refuse to deal with competitors and when it's allowed in digital markets. In a way, I'm happy with the fact that the court took up this opportunity, but this is where the problems begin. I'm not particularly happy with how the court distinguished the present case from the previous case law on refusal to deal and what it made with the new conditions that it came up with. So one of the biggest things that the court does is that it introduces a distinction between the kind of platform that Android Auto is and previous infrastructures. And I'm using the word infrastructure intentionally, both because it's a broader generic word, but also because the judgment itself, in parts, is a little vague. That the judgment introduces a distinction between platforms like Android Auto and infrastructure of the kind that the court said it has been dealing with all this time when it comes to refusal to deal. And the difference is that the platform, the Android Auto platform, was created not to be used exclusively by the undertaking that developed it, but rather it was developed from the outset to be used by third parties. It's an open platform by design. Google never created Android Auto or Android, the operating system for that matter. It never created it to keep it for itself, but rather to make it open to third parties. Whereas the previous case law that the court relies on involve inputs that were developed for the use of the undertaking when a competitor asks for access to those inputs, to that infrastructure. The undertaking suddenly finds itself in a position that has to share something that it previously wanted to keep for itself. And this is the important distinction that the court introduces between, to simplify, open and closed platforms. And this is the distinction that then allows the court to say, since the facts are different in this case, since we're dealing with a different type of platform, that allows me to come up with new conditions that are different from the Bronner conditions. So I don't have to apply the same refusal to deal conditions that we've been dealing with in the last 30, 40 years. I can come up with new conditions that will apply to what I now call open platform.
On this point, the general court, namely in Google Android and Google Shopping, it really highlighted the fact that the presence of a restriction of competition existed because Google evolved from an open to a closed ecosystem. So I was wondering how you would square the circle, or what type of coherence we can expect in terms of what should a platform do to avoid being applied, for instance, the refusal to deal theory of harm, because it really seems that no one can really get it right. Whether you are an open platform, you will have to provide more interoperability, more access to competitors. Whereas if you are a closed ecosystem, you will be captured in other senses by regulation. So I was wondering how you see that type of argument coming together.
I think I'm going to answer your question in two stages. One, I have some thoughts on this open closed distinction, and then we can definitely talk about how the court could have, with small tweaks, made the Android Auto case much better to account for the special features of what it calls open platforms, but without going as far as to really lead with no protection open platforms. So let me go back to what you asked me just now on this distinction of open and closed, and particularly this idea that a platform starts as open and then gradually closes, and competition law must have something to say around this. So the problem that I have with the distinction between open and closed is that there is no such thing as fully open or fully closed platform. And this is very important because the court, when it introduces this distinction, it attaches different investment incentives and different property rights to open platforms and different investment incentives and property rights to closed platforms. But the reality is that if platforms are not or never fully open or fully closed, it means that the reality of investment incentives and property rights falls always somewhere in that gray zone in between. So the argument that the court made here was that for a platform that is open, like Android Auto, if we make the platform deal with a third party competitor that you would otherwise not deal, doesn't really harm your investment incentives, because from the outset you were planning to create an open platform. And it doesn't also harm your property rights because you developed that property to share with other undertakers. And there is some truth to that, but the reality is that when undertakings develop a platform, they don't necessarily, even open platforms, develop it without any control or any limit to the platform itself. Sure, they want to share it with third parties. Sure, they want to make it mostly predominantly open, but that doesn't mean that they are willing to relinquish all control. And the incentives to invest and to create in the platform or infrastructure are still there, but instead of the investment incentives to be, I want to develop that for myself, and therefore I absolutely don't want to give it away, they take a different form, which is I want to develop it for third parties to come along, but still on my terms and conditions. And when you force a platform to open it beyond those terms and conditions, you're still upsetting the business planning and the incentives and the property rights the way that the undertaking designed the platform to be. So you're still interfering with incentives and you're still interfering with property rights very, very well, because the developing undertaking still has a life cycle approach to the platform, and it has a thinking about how much it will open it, to whom, and under which conditions, and all of these considerations feed into its investment and in incentives and planning. So I don't think that this clear-cut distinction between open and closed platforms was suitable to carry this weight that the court attached to it, because the implication out of that is that once we create this new category of open platform, we're done with Bronner. We can come up with new conditions. And indeed, the court did come up with new conditions. Not only did the court come up with this new category of platforms, and since it moved on from Bronner, it felt that it can apply new conditions. But the new conditions, because the court felt that, oh, it's an open platform, we don't have to protect investment incentives or property rights, it very, very substantially lowered the new conditions that it attached to this new obligation. So in this table on the slide, I try to summarize the new conditions and compare them to the previous conditions. And you will notice that where in the previous condition, in the previous Bronner case law, the court required that access to the infrastructure be indispensable for the competing undertaking to compete. Under the Android Auto decision, access to the platform need only make the competing application simply more attractive. And to me, the comparison between access is indispensable and simply making your product more attractive, the difference between those two thresholds is vast. And in a way, one can even go as far as to say that any additional feature or any additional ability that you endow your application with, in this case, access to Android Auto, can make your application more attractive. And so it's an incredibly low standard to meet to simply have to say, if I get that from my competitors, my application will be more attractive. So this is kind of like a very dramatic departure from previous case law, which again is unleashed because of the distinction that the court introduced between open and closed platforms. Secondly, the previous case law talked about the effect on competition, that if you don't get access to the infrastructure, then competition is eliminated in that secondary neighboring market. An elimination of competition is again a very high threshold viewing. And instead of elimination of competition in Android Auto, we have hindrance of competition. Because one of the things that became apparent from the fact-finding exercise of the Italian Competition Authority was that NL stayed in the market and its app also stayed in the market and still continue to be used by a smaller user base compared to Google Maps, but still it wasn't eliminated from the market. And so to move from needing to show that competition is eliminated simply to competition is hindered, again, it's a vastly lower standard, because essentially every time you make it harder for your competitors to compete, competition is hindered. And if your competitors still stay in the market, in fact, even if your competitors are increasing their market share, you can still make an argument that competition is hindered, because if you had granted them access to the infrastructure, then they would be in a much better and much stronger competitive position. And then lastly, in Bronner and in the previous refusal to deal case law, the court allowed for an exception of objective justifications. So if the refusing undertaking had some objective justifications to refuse access to its infrastructure, the court would be willing to entertain those, which of course is in line with the general theory of Article 102. And in Android Auto, it's not that it rules out the applicability of objective justifications, but crucially, Google did raise an objective justification, which was that we don't have the necessary infrastructure in place to allow Juice Pass to come on board on Android Auto. For apps to be ported onto Android Auto, Google needed to develop a template which would interlink the app with Android Auto, that special mode of Google Android. And Google said, we don't have that template. We need to develop it from scratch. But that was not an objective justification according to the Court of Justice. So what it said instead is that if a competitor asks for access to your platform, you cannot say, I don't have the necessary tools to enable that. You have to develop the tools, but we can discuss on how quickly you should develop the tools. The requesting party should compensate you for the cost that you will incur, and it takes into account some integrity and security exceptions as well. But all of those are on the back of first having established that you have an obligation to develop the infrastructure to allow the party to come on board. And so, again, even in terms of how it interprets objective justification, it severely limits the scope of those exceptions. So, if I had to synthesize all of that, the new standard, the new refusal to deal doctrine for open platforms is simply that if you show that a platform to which you seek access was developed not for the exclusive use of the undertaking that developed it, all you need to show to request access is that getting access to the platform will make your offer more attractive, that if you don't get access, competition in your market will be hindered, and the undertaking behind the platform to which you seek access cannot say that they don't have in place the necessary tools to allow you access. And so, to me, it's fairly easy and uncomplicated to show that a platform was developed not for the exclusive use of the undertaking. In fact, honestly, if a platform has been developed for the exclusive use of an undertaking, it's hard to even imagine how other undertakings, and I'm putting aside questions of like utilities like telecoms and rail and all of that, but in the digital world, when you develop something for your own exclusive use, it's very hard to imagine how a competitor would even know about it or even build an entire business plan that would require access to that super internal, super exclusive platform or tool that you have developed for yourself. To show that if you don't get access, competition will simply be hindered, not eliminated. Again, very easy. And the undertaking whose platform you seek access cannot refuse by saying, I don't have the necessary technical infrastructure in place to allow you to do what you want. Again, that's not going to fly. So the court is making it incredibly hard for open, in quotation marks, platforms to refuse any request from any business, no matter how silly the request can be. And that's why it has been compared to, a moniker essentially that was floated around after the Microsoft case came out, that this is not an essential facilities doctrine, this is just a convenience facilities doctrine.
On that point, and I'm specifically worried with the second requirement relating to effects on competition and how elimination is not going to be applied in this context of open digital platforms, and hindrance of competition is going to be applied instead. Anything that has a really low impact on competition would fall within hindrance of competition. So as you were saying, with the development of business models and how competitors can really interact with ecosystem holders or platform owners in the digital space, it really seems that potential competition could go into the mix.
The court that still relies on previous case law on refusal to deal. It doesn't say that like our previous case law is dead to us. If that is still good law, you will remember that in that case law, and Microsoft did repeat that, the court says that even in a hypothetical market, if competition is eliminated, that is still enough. So if we combine that old case law with the new Android Auto case law, does that mean that competition in a hypothetical market is hindered? Is that still enough? If that's the case, then the standard is even lower, because you can make up a hypothetical market and potentially show that competition would be hindered in that market.
In that sense, Konstantinos, I was thinking that competition authorities, in essence, will be able to say this kind of innovation that we have not really seen in the market, but we think that is feasible and possible, then it can really equate to the kind of competition that we want in the market. So this is the competition that is hindered from the market.
Right, exactly. So it allows you to construct a theory of harm so broad and somewhat tentative, it makes it like almost too easy. Now, if I may, I've been critical to this case, but I think it's important for us to highlight that it was about time that the refusal to deal doctrine be updated for digital platforms. I think that the court and Advocate General Medina, they were right to think that there is something different between a platform like Android Auto or digital platforms and the old economy. I don't have a problem with the fact that the case introduces a new doctrine, but it was To my mind, it was relatively easy to introduce the doctrine in a way that was so much better calibrated that it could still give us something useful for open platforms, but something that strikes a better balance. Let me offer some thoughts in terms of how the judgment could have been improved in very specific and very realistic and very practical ways. So, to the distinction between open and closed platforms, as I mentioned, there is no such thing as fully closed or fully open platforms. There is no platform that is so open as to say, we give it out to the world, there are no terms and conditions attached, anything and everything goes. What the court could have done is to construct a concept, engage with the platform literature, acknowledge that there is no such thing as open and closed in a binary distinction, kind of like a very dichotomous way of open and closed. And it said, say that the new doctrine that I am developing will apply to predominantly open or predominantly closed platforms, or that would apply to by default open or by default closed platforms. And the definition of by default open would be something like the presumption is that access to the platform is granted, except if it violates certain terms or if there is kind of like some sort of particular situation why access would not be granted. But the presumption is that if you comply with certain terms, you can expect that you will gain access. Now, that's very different from platforms that are presumptively closed or by default closed or predominantly closed, where the rule is that you don't expect to gain access except if there are special conditions in place. And so by introducing this kind of by predominantly open, by default open, presumptively open terminology, which the court could define in the judgment. And of course, it could say that I believe that Android Auto is a presumptively open platform or by default open platform. It would at least allow competition authorities and then courts to say that we have to examine, we have to prove that a platform is not just open, meaning not for the exclusive use of the developing undertaking, but rather mostly or predominantly or by default open. Secondly, when it comes to attractive, instead of saying that access to the platform would make it attractive, the court could have said that it would substantially facilitate competition in the market. And again, simply just adding facilitate in that would at least raise a little bit the threshold of what needs to be proven. You no longer talk about simply attractiveness or hindrance of competition. You talk about substantially hindering competition or granting access would be essential to the competing undertaking. And so, even just changing attractiveness to essential, that would make a difference. And even if changing hindrance of competition, adding substantially hinder competition, that could make a difference. So it's tweaks like that, adding a qualifier or replacing a word for another word, that I think that the court could have maintained the overall direction of where Android Auto wanted to go.
We could jump to how the Android auto ruling also impacts the DMA, because we are talking about the same undertakings being captured by the DMA and also Article 102. And also, this kind of conduct could be really interpreted as a means of denial of interoperability, which is already also contained under Article 6.7 of the DMA. So I was wondering how you interpreted that so that we can wrap up the episode.
Android Auto speaks a lot about platforms, but in different places it also mentions the word infrastructure. And so, how broadly this judgment can be interpreted is an open question. And I'm raising this because the DMA speaks of gatekeepers. Android Auto, a narrow reading, speaks of platforms, but a broad reading, if you look at the obiter dicta of the decision and if you look at the various parts of the Advocate General opinion, it speaks about infrastructure. So conceptually, the Android Auto decision can be read broadly to include not just platforms, but any infrastructure. And so we have this uncertainty as to what kind of infrastructure, broadly speaking, Android Auto applies to. Is it only platforms? Can it be gatekeepers? Can it be more than gatekeepers? And where we come out on that question also affects, of course, not just the applicability scope of the judgment, but it also affects how the judgment interfaces with the DMA. It is a little peculiar to me that the Advocate General does mention the DMA in the opinion, and it acknowledges that it's a given that this decision will have impact on how the DMA is applied. But then it goes on to analyze the facts of the case and the relevant legal doctrines without breathing in the DMA again into the discussion at all. And the court does the same thing. So the DMA really plays zero role in this, even though its existence was acknowledged. Now, the reason why I find that a little problematic is that the whole purpose of the DMA was that it recognized that is a market here, that we can try to sort it out, we can try to maintain it under conditions of healthy competition, but so far we failed. We've had numerous judgments and numerous commitments with Google and with Amazon and with Apple, and we start to realize that we need an ex ante mechanism to regulate how these undertakings deal with their competitors and their rivals. Once we adopt the DMA, which supposedly calibrates competition between the gatekeepers, these big platforms, and its competitors, we have a judgment like Android Auto that suddenly says there is this thing called the DMA. We don't discuss it at all. We don't care what it does. So we're just going to go ahead and impose whatever obligations we think are the right obligations, and we don't examine at all how these obligations interface with the instrument that only a couple of years ago we came up that we're supposed to regulate exactly the same subject matter that we are called to regulate today through this competition law judgment. And so that comes on the back of, again, a long case law in EU competition law that says that prior regulation does not foreclose the applicability of competition law in these markets. And we know that from T-Mobile and telecoms cases, that the fact that an industry is regulated doesn't mean that competition law does not apply. And so all of that is fine. But again, I would have expected the court to take into account what the DMA does and calibrate the applicability of the Android Auto judgment to take into account the obligations that the DMA already imposes. I'll leave it at that, but it's one of those little annoyances around this case that creates this kind of like sense that I'm not too confident that this whole thing is going to work out, because platforms find themselves in a position that now they have to balance what they need to do under the DMA, but also potentially what they need to do under the Android Auto decision.
Thank you so much, Konstantinos, for all of this detail around Android Auto. And I really recommend the audience to read your paper. I believe it's available on SSRN, so Platform Competition After Android Auto. Thank you so much for joining us here in the Agora. Bye-bye.
Thank you likewise for the invitation, and I would be happy to answer any questions that come my way after people read the paper. So thank you again.